Sure. Hi, everyone. Like she said, my name is Bethany Gaal. I've been with Patent Hatchery for a few years now. I will do my best to speak slowly, but sometimes I start going fast. So I will try my best to kind of go at a slow pace so everyone can kind of understand. I know we've got a little bit of a language barrier here. I wish I spoke Russian, but I don't. I'm sorry. So let's go ahead and just get started here. If I can get my technology working. There we go. So hold on, let me move this to the side over here. There we go. Okay, so basically in the US, a trademark can be a lot of different things. You can put a trademark on. The most common things are obviously your brand name, or your product name. And then a lot of people choose to do their logo. You can do both. You can do what's called a standard character mark, which would be just the words themselves. And then also with a logo, you can do the pictures or something like that. A lot of less common ones would be sounds, 3D images, packaging, things like that, movement marks, if you have a logo that's animated or something like that. Once you're registered in the United States, you can use the little, the R symbol that's on that purple oval right there. And if you don't have a registration, an official trademark registration, you can still use the TM beside your trademark. That's for goods, if you're selling a physical product. And then SM would be if you have a service like a consultation business or something like that. So you can use TM and SM without actually having a registration. And you can even use those even if you don't have an application. So you can just use that anytime on your mark. Because that kind of serves to put the public on notice that you are claiming rights to that mark. So we have thing in the United States called common law rights. So that would be if you're using your mark, you do have some sort of rights to it. Now that's not as strong as if you have a federal registration, obviously, but you do acquire some rights to your brand name, to your mark, to whatever you're using. The longer that you use it, the stronger your rights are. Okay, so we have some. Once you apply in the United States, whether it's through Madrid or through directly through the US PTO, you will go through an examiner, an examining attorney, and they will kind of go through the substantive issues, the substantive merits of your application. And they'll either let it go through onto publication, or they will issue an office action refusing it on a number of grounds. And we have here some of the most common grounds. Probably the most common reason for refusal that we see is likelihood of confusion, which means that your mark is too similar to another mark that is in the database already. And they base it on two kind of criteria, whether it's similar in sound and appearance, and then how closely related your goods and services are. So you could actually have the same exact, trademark as somebody else. Say your trademark was, Apple. That's kind of the example we're using today. But you don't sell any kind of electronics, any kind of software, anything like that. Say you sell, I don't know. Shoes, there we go. You still have a chance of getting registered, even though, well, probably not with Apple because they're so famous, but a lesser known mark, you would be able to do this. If your goods are so different, then they will not consider it, similar for their purposes. So, and in the next slide, we'll get to kind of how you prevent that from happening. Another one is merely descriptive. We do see this a good bit with foreign applications. And the exact language that they use is they consider it descriptive if the trademark describes an ingredient, quality, characteristic, function, feature, purpose, or use of the specified goods or services. So using Apple again, let's say that you had a fruit stand and you called it Best Apple Company or something like that. That would be considered descriptive of what you're selling. And so they would not allow you to do that. We do have something called the Supplemental Register here. And if your mark is descriptive, you can get on the Supplemental Register. And then after 5 years on that, you are eligible to move to the Principal Register. So it's not a completely, a wash if your mark is considered descriptive. Now, if it's considered generic, they will not let you register on either the Supplemental or the Principal Register. So you want to come up with a trademark that is unique. Made up words is what they consider to be the strongest marks. And it's probably, I would assume, the same in Russia. You cannot trademark the name of a living person unless you have their written consent, and you cannot register the name of a deceased US president in any case. And then I understand that we have a lot of questions about this, registering geographic names. If you're trying to register a place, the name of a place that is where your goods are coming from, then they're not going to allow that because they'll consider that descriptive as well. A good example would be, we had something involving Chernobyl a while back, and they considered that it had the name Chernobyl in it, and it was based in Chernobyl or based around that, and they considered it geographically descriptive and they wouldn't let us do it. So you probably don't want to try to trademark the name of a place if that is where your goods are originating from or where you are based, if that makes sense. We might have some questions about that, I would imagine. Right.
I recently heard about registration of lots of Crimea wines. So it cannot be registered because it is originated from Crimea, besides all other political things, but just because of geographical origin.
Right, okay, that's a good example. Let's see. All right, so now we're going to talk about how to kind of avoid the likelihood of confusion. There is something in the US PTO, a resource called the Trademark Electronic Search System. We just call it TESS for short. It allows you to basically do kind of a knockout search of what trademarks are already registered, which ones have pending applications in the US PTO database. And that can kind of help you narrow down some names if you're not set on a name yet. And it can also tell you what kind of obstacles you may encounter if you already are set on a name and you've applied for it. So generally, the basic word mark search right there is the easiest to use if you're not familiar with it, if you're not familiar with the system. And this is kind of what it looks like when you click on that. So you can search a number of different criteria in the search bar. Right here, we have full mark. You can search by the owner name. You can search by the goods and services. You can search by the attorney, actually, that's assigned to it, or just a portion of the mark. And this can get very complicated depending on how deep you go into it. But yeah, say you wanted to search for Apple, you could, and that's the whole thing you want to search. You don't want to know if it's, Apple Incorporated, whatever. You just want to see marks that are Apple. You could put full mark. And then, if you want to know which marks Apple owns, you could search by owner name. And then it'll bring up a list of marks that are in the US PTO database. And it'll tell you whether they're registered, whether the application is pending, and whether it does include what we call dead marks in the database, and those are just marks that were abandoned for whatever reason, and those are not something you have to worry about. They do not issue refusals based on those. So that's that. Hold on one second. Okay, the next kind of subject that we'll go to here is how to keep your trademark alive. Once you're registered, you do have to maintain the trademark file maintenance documents. And you see that registration date circled down there. That's important because from that date is what they calculate when you have to do these filings. So there's two main ones in the US. We have a Section 8 Declaration of Use, which would be after you've been registered for 5 years, you must file this, and you have to prove use in commerce of your mark, because they won't allow you to register a mark and then just stop using it. They'll end up canceling your trademark registration if you don't continue to use it. So, and it's really easy to prove. All you have to do is file what we call a Specimen of Use. And that would be it could be your web page, it could be your product packaging, it could be an invoice, anything that shows that you are using your mark, what they call in commerce. So it would need to have your trademark, it would need to show some sort of connection to the goods that you have registered, and then either a way to order, a way to contact, something that shows that you are actually selling or, using your trademark.
Excuse me, can I add a few words?
Yeah,
Here
absolutely.
we have some kind of rejections for trademarks coming from Russia. First, for example, a person is registering for example, loudspeakers. That's what he is actually selling. But on top of that, he is adding class, which is completing some kind of documents or advertisement in magazines. This is actually what he is doing, but this is not what he is selling.
Gotcha.
If you register like advertisement in a magazine, means you are getting money. You are selling advertisement in those magazines, not that you are doing this activity. This is a difference. You have to get money for what is called in commerce, right? Yeah. Just quick.
You had to, you don't, I guess, necessarily have to be getting money. Well, yeah, I guess you do. I was thinking of nonprofits, but even that, you would be kind of a transaction. There has to be some sort of transaction between you and a customer. You have to have customers, I think, would be a better maybe way to say it. So yeah, if you can't say advertising as one of your services if you're just advertising for your company, because that's not considered a transaction between you and a customer. That's just you promoting your business.
Yeah, Bethany, we did have a lot of such cases, right?
Yeah, we have. A lot of people wanted to register promotional, things like where they would set up a tent and hand out, little tchotchkes or whatever. That's just you promoting your business. That's not selling something. That's not, it's not used in connection with what your trademark represents, if that makes sense.
Okay, can I also add, it usually refers to class number 35, yes?
Yeah, 35.
This is, so be very accurate with applying for class number 35, because you have to provide the services listed on it. If you just use these services, if you're a client of the services, you are not necessarily providing these services. So be careful with choosing class number 35.
If you're an advertising company or an advertising firm and you are providing advertising for other companies and they're paying you for that, obviously that is different, and that is what that class is for. Any other questions on that?
I think when we apply for a trademark, I think there is a difference when we go from Madrid System and we apply to US PTO. Is that right? I mean, it refers to a statement of use. if we apply through Madrid system, we need to send application, not application, declaration of intention to use. Yes, it's some extra form, MM18, which is a part of our Madrid application documentation. And so we just declare that we intend to use this trademark, and that is something different to when we apply to US PTO. Yes. So.
Right. Well, that would be when you're applying. Yes.
Mm-hmm.
You can apply on an intent to use basis. That will not let you register in the United States, though, until you are you can actually prove that you're using the mark. You can apply, go ahead and apply on an intent to use if you're not using it, but they will make you prove use before they'll actually let you register. Now that gives you like 3 years if you file extensions and stuff like that. But that, that's fees and more time. So I always
have a question in the chat regarding those extensions. So once you get allowance in the US, you need to provide this proof of use, and you can extend for 6 months, another 6 months, another 6 months, up to 3 years. But you pay each time for buying this next 6 months. But many companies do that, especially American companies, by the way.
Yeah, they do. It's because they know they want the protections and they don't want anybody else to have it.
Yep.
So they go ahead and do that. And yeah, that is what a lot of people do. To save yourself time and money, though, it's better to go ahead and be able to prove use fairly soon after you apply or when you apply. Okay. So that's when you're applying. Yes, you would file the M18 and say that you intend to use. Now these on this slide is after you're registered. You have to maintain it. So the Section 8, we kind of went over that. You have to file that between the 5th and 6th year after you're registered, and then between the 9th and 10th year, and then every 10 years after. So your trademark registration will expire every 10 years unless you file these documents. So it's not, it doesn't go on in perpetuity. And then we also have something called the Section 15 Declaration of Incontestability, which I understand you don't do something like this in Russia. So this would be where if you're registered for 5 years, you can file this declaration with your Section 8. And it basically says, I have full rights to this mark. Nobody can challenge it. Nobody can try to, come and cancel my trademark in court, because we do allow people without trademarks to try and cancel registered marks. So you're not completely safe once you're registered. Obviously, your rights are much, much stronger. And it is very hard to cancel a trademark. But that declaration puts a stop to it, doesn't even let it, go through. So that's something that, I advise people to do. It does, I think it's $100 to file it. But it's very easy to do. You just file it in conjunction with Section 8. So there's that. And then with Madrid, it's kind of the same thing. We don't have the Section 15 with that, so you would have to apply directly in the United States for that. But we do the Section 71 Declaration of Use, which is the same exact thing. It's just under a different statutory, provision. So that's why they call it Section 71. You just have to submit the specimen that we talked about. And it's the same kind of time limit. You do it between the 5th and 6th year, then the 9th and 10th year, and then every 10 years after that. And there is a grace period. There's a 6-month grace period following the expiration of each of those years, but you do have to pay an additional fee to file within that.
Can I add that these periods are calculated from the date of registration with the US PTO? If you are doing something with Madrid system, your date from which the time, this 5-year period calculated, is date of registration in the United States of America, not the date of your international application, not the date of your priority of the basic application, but date of registration in the United States. So that's important.
Right. Yes.
And about this incontestability, if you have any questions, please also ask them, because it's something unusual for Russian applicants. So if it's clear, that's great. But if you still have this question, please, we will come back and discuss it a bit later.
I can pause right here before we get into this next thing. If there are any questions that we need to address, are we good right now?
No, for now, no questions.
Okay.
For now. It's okay.
All right. So this is the Madrid system. The Madrid Protocol is a treaty. You probably know this. It's a treaty that a lot of countries in the world signed that basically allows a streamlined process for getting protection in different countries for your trademark. It allows one international application that is sent to a bunch of different countries at one time. If you're wanting protection in a lot of different countries, absolutely, this is the way to go. It's cheaper, it's much, much faster and more efficient. You know, if you're only wanting, you know, Russia and United States, it probably doesn't matter really. But you do have to file what they call a basic application, which would be in your home country. You would file with your home office. So if you're a Russian citizen, you would file with the Russian, what is it called there? The Russian IP office, the trademark office?
Kind of, yes. Rospatent.
Okay, well, you would file through that. In the United States, obviously, we file through the US PTO. That's considered your basic or your national application. Then you would use that to file with WIPO through the Madrid system. I know it sounds complicated, but it's really not. You would file an international application with the World Intellectual Property Organization. And what you would do is designate all the countries that you want protection in. And there is, you know, the fees can get substantial. It's calculated in Swiss francs, or francs, however you say that. So the cost can kind of fluctuate based on your country's currency up against the Swiss currency. So they do have a fee calculator on the World Intellectual Property Organization's website. It's a Madrid Fee Calculator. I put the link at the very end on the last slide if you're interested in that. And you can go through and see exactly how much you're going to have to pay for however many countries you want. And that will kind of help you see what you can afford, see what countries, you know, maybe are more important to you than the others. And then what they do is they send your application to all these different countries, and then their individual offices will do an examination on it. And it's definitely not guaranteed. You can get rejected in any number of countries. But, you know, you can end up fighting it like we would here.
Bethany, remember we did this conditional system trademark? How many countries it was? It's like 37?
So, yeah, it was a bunch. Ended up being,
like in one application, 37 countries. This is just one of the examples. And here I would like to talk just a little bit about European application as one country, because you can file European application in which there will be another 30 countries.
Yes.
But the problem with European application, if in one country it will be rejected, it will be rejected in all Europe. So we had this situation when we filed trademark in Europe, and only in Italy it was the similar trademark. So the whole European application was rejected.
Right. Yes. So, you know, it's great that the European Union allows, or that Madrid allows you to file in the whole EU, but yeah, that can obviously not work in your favor if something like that happens. And another thing,
remember, we also did African Union.
There's an African coalition or whatever it's called. that allows you to file in several, I can't remember exactly how many. Do you know, Nadia? How many?
Well, 17 countries or something like that in this African Union.
And that kind of lets you, get the bulk, if you know you want to register in all of Europe, which most people do, that allows you to not have to go through and individually pay for all of those. Something to note is that as of right now, for the next month, the UK is still part of that EU designation. But as of January 1st, because of Brexit, they will no longer be part of that. And you will have to file a separate, or you don't have to file separate, but you'll have to designate them separately. So if you want to file in Europe, it's definitely beneficial to do it this month because it saves you some money there. Yeah. Any other questions on that? I think we're good. Okay. I know we have a lot of questions on this. Why do we correct the description of goods and services in trademarks from other countries? So there's something called the NICE classification system, which is kind of the international goods and services classification. And then most individual countries have their own classification system. As of right now, the US PTO is pretty different. Have to go through and correct a lot of, the goods descriptions that are coming from different countries. We were talking about this earlier. What I see a lot is an over-inclusiveness with foreign applications. So they will include, they'll have mile-long goods descriptions, which makes it a lot harder in the examination process, because the longer your description is, obviously, the more chances there are for mistakes. What we try to do is maybe make your description as short but as broad as possible. So instead of saying, going through and naming every single computer part that you sell, you would just say computer parts, and then you could say namely, and then add what I know this isn't making sense, but that's what you would do in the United States to kind of streamline the goods description. And then a couple of just little nuances with the USPTO ID. We don't use colons, we don't use periods, and we don't use brackets, which I know most other countries do use the brackets to kind of designate or specify something. So in the US, brackets usually mean to delete something, so we don't want to, confuse that. And we use semicolons to separate goods that are different from each other. Your US, this is something good to note, your US goods description may not be broader than the description in your international application. So you can't expand your goods list or your services list in the United States. You can only narrow it. Yeah, so that's that. The US is working currently to tailor its ID manual to be more similar to the NICE classification. So hopefully we'll see less and less of this come January, but we'll see. I don't know exactly what changes they're making or how similar it will be, but that is coming within the next month.
Yeah, may I add a little bit? So in most of the cases, what we correct in applications from Russia, if it says sport equipment, examiner asks to clarify what kind of sport equipment. If you say business services, what kind of business services? So each time they ask more specific, what are you doing? This is typical correction that we are doing in applications from Russia. And also никаких скобочек вот этих вот, никаких там вот этих лишних знаков. Bethany, I'm talking about brackets and semicolons. Никаких вот этих, все идет через точку запятой, и все. Okay.
But also, I would like to add that according to our practice, if we have a Madrid application, every time we get a request from US PTO examiners, even if that list was already corrected by another US PTO examiner, usually there is a request, because I think it depends on the examiner, on a person. And we must consider, yes, that if we go through Madrid system, there will be a request, and we will need the help of US patent attorney to help us to correct it, because it's just reality, actually.
It's the nature of it, because if you're filing an international application, you're filing for the same goods in every country. So yeah, you will more than likely have to correct something, but the US examiners generally tell you exactly what they need it changed to, or exactly what they need clarified. So it's really easy to kind of go back and make it compliant. So yeah, that's a good point.
So let's, we have a couple questions in the chat. Maybe we will address them now.
Sure.
Okay, first question is, actually, I think we already talked about it, but if we if we're Russians and apply for the trademark in US, do we still need to file a declaration of use? And what kind of documents can be used?
If you are filing, are you saying if you're filing directly in the US as a Russian citizen?
Yeah, if you're filing directly, then you need right away at the time of filing. But if you go through Madrid protocol, you need in 5 years, right?
No, you would have to prove, oh, the declaration of use. Yes, I'm sorry.
Declaration of use you need in 5 years.
Yes, in 5
And
years.
the second question is, can the declaration under section 15 be filed? Oh, there are more questions.
Yes, just a second.
Declaration under section 15 be filed after 6 years of registration. Are there additional fees? What additional docs must be applied for this type of declaration?
So you don't need any extra documents. Or are you saying if you file it after the 6th year? Yeah, you can file it at any time, but it's much easier to file it at the same time you file the Section 8, because they allow you to do it on one form. And then you can use the same specimen for both. So if you're filing after that, then yeah, you would have to have another specimen of use, and just file. There's a spot on the US PTO website for a section 15, and you just go in and fill it out. It's really easy to do. The hardest part is getting a compliant specimen. So yeah.
The next question is, about the statement of use again. If we have Russian website registered, hosting is in Russia, and we have English version of this Russian website, the question is it necessary that hosting will be American, or it can be Russian hosting?
No, yeah, you can have a Russian hosting, a Russian host site. And you said you have an English version. Something important to note that I think Nadya and Jane and I talked about was, if you are you don't have to submit something in English. Like say you only have a Russian language website, but you still want it trademarked, or still want it protected, you can file and use that Russian language in your as your specimen, but you do have to provide a full English translation with that. But yeah, we do allow, we allow any kind of hosting site, as long as it's, the same trade.
Не только хостинг может быть русским, вообще можно подавать подтверждение на русском языке, только нужно его сопровождать английским переводом того, что вы подаете. If the company has enterprising solutions, it does not sell its goods through its site and does not put price on the website. All goods and all products are customized and the audience, the buyers are large business.
Mhm.
So, for example, well, I think this is a question. So if it is customized product and there is no real price for that.
Right. And we see that a lot. I mean, almost, I feel like the majority of the ones we do through Patent Hatchery are like that, don't you? They don't have a price listed on there because it is so customizable. But what we would need to see is some way for customers to be able to contact you, get a consultation, get a quote, something like that. A lot of people don't have, you don't have to have the prices or the add to cart or any of that, but it's just some way to prove that there is a transaction between you and the customer. Otherwise, they will say it's just advertising. It's mere advertising is what they say.
Да, то есть важно, чтобы это было не реклама товара, а чтобы была какая-то кнопка или какой-то «позвоните нам» или «нажмите кнопку, чтобы получить квоту на продажи» или «нажмите кнопку, чтобы обсудить покупку и возможность там предоставления нашего сервиса вам». Вот такие вещи должны быть на веб-сайте. Не обязательно должна быть цена, прямо корзина. Okay.
Nadya, don't you think the biggest issue that we probably see is finding acceptable specimens?
Yes.
For our clients? I feel like we run into that almost every time.
Самая главная проблема в российских трейдмарках – это то, что на самом деле нет подтверждения использования в США. Это самая большая. And Bethany, we also need the use in USA, so that not just use, right?
Right, yes, that's a good point. Yes, you have to prove use in the US to get registered in the US. I mean, of course, that makes sense. They're not going to register protection in the United States for something that you're not using there.
Yeah, I'm really glad to see when I come to Russian store and, sometimes you go to Russian store to buy some, Russian food, and I see many our customers, like Tambovsky Volk sunflower seeds, or Nezhin cucumbers, or, all variety of products that we already registered. And I'm so glad to see how many vodkas we registered. It's like the whole line of vodkas and cognac that are our clients. And they are really used. They are really sell in United States.
Yeah.
But sometimes it is not very easy, for clients from Russian store.
Yeah.
Can I add to this question, just to clarify? For example, the company has a service which is described on the English version website, and then they can sell their services to the US market as well. They have this description. Should they have some office in the United States as a contact office, or not necessarily? Yes.
No, that's not necessary. Just some sort of, that would be
just to prove the ability to provide these services for US clients.
Yeah. So you're saying they sell products on their website, but we would need to prove that they ship to the United States?
Yes.
Something that might be helpful in that situation would be to provide an invoice from a client, from a US client, obviously redact all the personal information, but just show that they did ship it to the United States. And that could kind of solve that problem there. And for when you file in the United States, you have to prove a date of first use anywhere, and then a date of first use in the United States. So 2 different dates of when you started using the mark. So yeah, you could say the date you first started using it in Russia, at the very beginning, and then also the date that you started using it in the United States. And the United States date is what they will base your common law rights on, I guess you could call it. Because the earlier you start using it, the more rights you have, like we discussed earlier. Okay.
Okay.
And there's another question in the chat. Sure. Who can communicate with US PTO directly as a representative of a legal entity? Easy question.
So the United States just either this year or last year, I think it was last year, passed a law that any foreign individual or entity must be represented by a US licensed attorney in front of the PTO.
Like Bethany.
Oh, okay.
Thank you. Yes. Also, I would like to add that according to filing application directly to US PTO with help of US patent attorney, even Russian citizen individual can have a trademark, which is unusual. Yes. Through Madrid System, it is not possible because the Madrid System application should be based on Russian application, and in Russia, an individual cannot be a holder of a trademark. So
if you are a Russian individual, though, and you want to file through Madrid, you could file an application in the US first as your basic application, and then file through Madrid. Now, I don't know how that would work if Russia would allow it to. I don't know. That would be.
You have to have US company in this case. You have to register US company. You can be a Russian citizen with a registered US company. It can be just registered. It's not, maybe not really functioning. And from this company, you can file Madrid protocol. We did it. We did it before. Okay. So, but another way. So you file it through the company, through Madrid, and then when it comes to the United States, it still belongs to the company. And then you make a rights transfer from the company to individual.
Okay.
We do lots of rights transfer, Bethany, right? So we can transfer from company to a person, from person to a company, from company to a company.
Yeah, and it's really not that complicated to do if you end up wanting to.
It's just in one day we can change it.
Yeah. Okay. Anything else on that?
Yeah, I want to mention purchasing trademarks that we just completed today. Actually, Bethany, the agreement is signed that you prepared. Okay. So there is another way that if you want to purchase somebody's trademark, US trademark, you can do that. And if the buyer, seller and buyer agree, today we signed agreement between the Vietnamese company, which is purchasing US owned trademark. So this is also possible, and it is all done with assignment of передача прав от нынешнего хозяина марки до вьетнамскому новому хозяину. Okay, all right.
Yeah, if you're still going to be the owner, you're transferring it from yourself to your company, then you don't really need the purchase agreement. It's definitely, the purchase agreement is much more involved than the assignment. If it's just you transferring it to your company, all we need to do is an assignment. But if you are actually selling it to a third party, then we would probably need to do the purchase agreement just to protect you. Yeah, okay. I want to move on to Amazon. I think this is our last, I know, or I've learned that Amazon is not as big in Russia as it is here. Doesn't have as much of a monopoly, like Jane said. But in the US, if you want to sell in the US, Amazon, it's almost a necessity, unfortunately, the way things are right now. I think that may change with other platforms coming in like Walmart and things like that. But as of right now, Amazon is kind of your way to go if you're selling a product. And I would say probably at least half of what I see is in my individual capacity is people trying to get registered at Amazon, because Amazon has something called brand registry, which is only available to people with registered trademarks. So what it does, it gives you a lot of different protections. It kind of gives you a way to enhance your listings, helps you get customer data. It's just a lot of different benefits to being in this program. And in the US, for brand registry, it's reserved for trademarks that are on the principal register only. So if you're on the supplemental register for your descriptive mark, that's not allowed currently. I think that might change soon from what I hear, but as of right now, that's not allowed. If you have a pending application, you can go ahead and be put on a waiting list, and they will accept you before you're registered, but you have to eventually show proof of your registration to maintain that. So I don't know if any of you are Amazon US sellers or not, but this is very important and very big here. And I think they have brand registry in Russia. If anyone out there knows, go ahead and tell me. But so yeah, that's something important to have a trademark for it.
The procedure is the following. So we register trademark for our clients, and then they submit this registration certificate to Amazon when they list their products on Amazon.
Mm-hmm.
And Amazon contacted us,
Mm-hmm.
our company, to confirm.
Right.
We need to confirm that this person and this product are registered. So it's we are legal company, so our word means a lot. So
right.
If we confirm, yes, this company is the owner of this trademark, only then they got registered on Amazon with a trademark, and then they can request elimination of anyone who wants to sell similar product.
Yes, a huge
This
problem.
is very important.
Yeah, it's a huge problem at Amazon right now. And if you sell on Amazon, you know this, is counterfeiters, people jumping on your listing and trying to sell off of your listing. It's the Wild West, honestly. So this is kind of an attempt to help, tailor that, help eliminate that. And it's doing a good job as of right now. There's a lot of other Amazon programs out there that help, transparency. I can't think of the others right now, but anyway, yes, it's I would say it's almost a necessity for selling on Amazon at this point. So yeah, that is that. Any questions on Amazon stuff?
We have it, but not about Amazon.
Okay.
I would like to add maybe one more word about supplementary register, just
Sure.
For Russian applicants to understand. So in America, please correct me if I'm not correct. In the United States of America, there are two registers: principal register of trademarks, which is very official, trademarks registered by US PTO with no questions. Trademarks are very strong, yes. And the second register is supplemental register, which is the register for descriptive marks, yes. Yeah. And if a mark is descriptive, it goes to supplemental register. And in 5 years, if this mark gets some distinguishment, it can go to principal register. So in fact, there are two registers, and both of them provide protection for your trademark.
Right.
It's just some extra option for descriptive marks.
Yes. The supplemental marks on the supplemental register are considered weaker. And so it's easier for someone to come and challenge them. But you still get to use the R symbol. You still federally registered and used, and your mark will be used as a basis for refusal of other marks. So yeah, I mean, if you have a descriptive mark and you're refused and they give you that option to amend to the supplemental register, then I always encourage people to do that. Something you do need to know though is if you file through Madrid, they do not allow those marks to go to the supplemental. They don't allow you to amend to that. So that's important to note. You would have to file directly in the US to be allowed on the supplemental. So if you think you have a descriptive mark, it's best to file directly.
So there is a question in the chat devoted to statement of use again. Can they use as a statement or maybe intent to prove intention of use the quotation for American client? Not the invoice, but
some offer for sale to somebody in US. Can it be?
Maybe the offer for sale, but a quote. Wait, do you mean a quote like they said this, like a review or something like that?
No, offer, commercial offer.
Oh, yeah. I would think that would be, as long as it's official and in writing, you know, that should be sufficient. Something that may be helpful, and I'll try to do this after this, is to kind of have a list of things that would be acceptable as specimens of use. Because like I said, that is the main issue I think that we see with our clients. And it's also, hold on, let me get to this right here. If you look at the TMEP right here, the Trademark Manual of Examining Procedure, it has a wealth of information on all of this. And they will go through and tell you exactly what an acceptable specimen is, and exactly what you need. That is an invaluable resource right there for an applicant, because it tells you exactly, you know, I mean, and it's long, but you can search through the headings to find what you need. So those are helpful links right there. Like I just explained, the examining procedure manual, definitely go through and look through there, kind of familiarize yourself with it. And it is so helpful. Tests, we went over that can help you do a knockout search, clearance search for, you know, likelihood of confusion, see if there's any other similar marks. Right, that next one is the US PTO ID Manual. And if you're filing directly in the US, go in there, type in what your goods or services are in the search bar, and it'll tell you exactly how to formulate what you need and exactly what class it's in. We talked about the Madrid Fee Calculator, and that next one is the US PTO Fee Schedule. It'll tell you the fees for, you know, the declaration of use, the filings, the extensions, anything that you need on there. And then if you just want more information on Madrid, you can go to that last link there. And that is it.
Yes, and here is our email.
Yes,
please write it down, and we always respond and always, you know, clarify things, and we do not charge for consultation and so on.
Yes.
So I encourage you, if you have some ideas how to prove your intention or usage of your trademark in the United States, please write Nadya and Bethany, and they will tell you if it's sufficient or it's not.
We are very experienced in that because we see it a lot. So yeah, let us know.
I have a question concerning preliminary search. If we use this test system by US PTO, we, for example, type our word mark, will this system give us some confusingly similar marks, or it will give us just the exact words which contain?
Well, I wish we had time to go in and do a search, but you can, if you want anything that will, you know, could be used as a basis for a likelihood of confusion, you can type in just part of your mark, and then there, instead of designating the full mark, you can, there's a designation there, I think it's called combined mark, and that'll pull up anything that includes what you typed in. And that's a better way to do it. My suggestion is always to get a professional to perform a search, either an attorney or a search database, a search company. Those can get very expensive though. CompuMark is a good one to use, though, if you want to just make absolutely sure. They'll search, you know, it's automated, it's a computer doing it, so it searches everything and tells you everything that could possibly come up, even things that most likely won't. But yeah, if you want something like that done, we can do that at Patent Hatchery. We can perform a search for you. But yeah, if you want to try to do it yourself, just go in and familiarize yourself with the system. There is a learning curve with it, but it's pretty easy to find out. And I think that there's actually a tutorial on there that will show you what to do. So yeah, that was a long answer for a short question, but
Thank you still. Anyway, I have another question. If there is a office letter which says that your word mark, let's say word mark, is confusingly similar to another mark, but you disagree with this examiner, are there really options to overcome this?
Yeah, I mean, we always disagree whether we disagree or not. So yeah, you would write a response to the examiner basically arguing why you disagree. That's a lot of what we do, is responding to those. We have all the legal arguments and everything. So, you know, I think it's best to hire an attorney. Of course, that's my attorney opinion, but I think you want to give yourself the best chance of success, and you want to have all the legal precedent for why, you know, your mark is not confusingly similar. So yeah, and a lot of that is really subjective. Unfortunately, it depends on the examining attorney that you get. Some of them could just be in a bad mood that day. So I almost always advise to fight it, even if you think it may be a losing battle, because you never know. You know, they could see your side. And there's, you know, even if they are like black and white, pretty similar, there's always some sort of argument that you can make. So yeah, you would file a response in the US PTO, and you would just put in there where it says enter your argument, you would just enter your argument for why you disagree there. And if they agree, then you get to go forward. And if not, then you don't.
Yeah, we always argue either similarity of marks or descriptiveness or geographical or whatever. For example, I remember the case, it was a few years ago, but it was Gorky Park rock group. Remember, it was Gorky Park group by Stas Namin. So we did register Gorky Park rock group in United States, and because of the Gorky Park, there were lots of arguments with examiner. So we went through all rock groups with geographical names like Nazareth and others, and eventually we won because and there are so many interesting cases that we have, and so many interesting clients from Russia that we work with.
Yeah, there's always a way. I'll say that. If you get a refusal, there's generally, you know, just keep fighting.
Okay. And also, can you tell us in a nutshell about interesting cases, interesting trademarks, maybe recently registered or?
Yeah, sure. We've had some pretty high profile cases lately. We've gotten oppositions from Facebook, from Prada, Sea-Doo. What were some of the other big ones, Nadia?
XM Radio, Sirius, and well, Airbus.
Yeah, just some big name companies that will go and kind of, it's called trademark bullying. They'll basically oppose your application just because they can, whether it's really merited or not. And most of the time we end up settling with them instead of going through the full. If you go through a full opposition proceeding, it can get extremely costly. But generally we end up settling these cases, and they'll either, you know, drop out or, you know, kind of make a compromise with us on something.
Yes, I remember the recent case where we had a client from Russia with a toys and kids playgrounds.
Mm-hmm.
So, это были детские площадки, которые они продавали. And the opponent wanted to remove everything related to boats. Убрать все, что относится к морским делам и к лодкам. Okay, it's okay for our client to remove everything related to boats because actually they sell playgrounds. То есть детские площадки с горками, там, ступенечками и так далее. Там, бог с ними, с этими лодками. So sometimes you can easily settle.
Yeah. And, you know, that's something to always be aware of is that these big companies, with all the time and resources that they have and teams of attorneys can try to come after you. And I just, you know, we always say, don't just lay down and take it because most of the time it's without merit. So anyway, yeah, that's some of the interesting kind of bigger names that we've gone up against, I would say.
Another thing I would like to add that we had cases when lawyers from these large companies, so именно юристы, которые представляют эту компанию, компания, это отдельная компания, это не юристы самой компании, а отдельная юридическая фирма, the law firm that represents interest of the large company, they filed, they sent letter to us, but they did not even ask the company. So after we do not really respond to them, they dropped the case because they did not receive confirmation from the main owner. It's interesting.
Those big companies kind of throwing spaghetti at a wall and seeing what sticks. They just throw a bunch of stuff out there and see what they can be successful with. Another big one was Ford, I forgot about recently. We had some meetings with some of their lawyers about, we were trying to register something that they had, some type of car or something. And we ended up being able to do that. So it's always best to try to talk to them and work it out. So yeah.
Можно я переведу на... I would like to translate your expression about spaghetti.
Oh yeah, sorry. Sorry.
Бедная сравнила, что большие компании, они кидают вареные макароны на стенку и смотрят, если что-то прилипнет, то хорошо, а упадет, то тоже, ну, не страшно. То есть вот такой вот шанс. Они хотят убрать тех, кого могут убрать легко.
Нет уже мастерство патентного поверенного, на самом деле, оценить риски, да, вот в необходимости ответа и отстоять в случае необходимости.
Okay.
So, please, if you have any questions, please write them in the chat. In Russian, in English, whatever, we will translate if necessary.
Jean, does anybody need me to put those links back up? I just realized I didn't ask. I just took it down.
So if you wish to get these links or ask any question, please write. Nadya, could you please type email address again so that people can save a chat from this Zoom and it can be written.
I'm clicking chat, but it doesn't appear.
Here,
oh, no, it's on the right. So, okay.
Yeah.
So it is admin.
Our presentation conference is recorded today. So we will process it and we will send the link to the video to everyone who have got registration through TimePad. So if we have your email address, we will send you the link to the video of this webinar. And again, really welcome you to ask questions. I think that we can even, if it's easier for you to turn on the sound, I will try to do it just right now. And please
Я думаю, что уже час мы разговариваем, и,
Maybe
наверное, достаточно.
quite, yes. But still. Mhm.
You're welcome. Saw that one.
So once again, the goals of our webinar, of our project IP Legal English Speaking Club is to share experience and to speak English in IP area. So I hope this webinar was really interesting.
I actually learned a lot about Russian trademarks, so that's good.
We wish everyone to be healthy, to be wealthy, the very best throughout this year. Also, I wanted to add that using Madrid system in January, there may be the fees may be higher, will be higher. So if you are thinking to file an application to get a trademark in the United States using Madrid system, December is a very good month to do that.
Yeah, definitely.
Yes.
So I think we should finish for now. Again, if you have any questions, please write to the email address provided by Nadya. And I hope we will see you next year online. We will proceed with our project. If we get a lot of interesting questions, we can come back again to this topic of registering trademarks in the United States. If again, there will be request. Thank you very much then.
Thank you, everyone.
Thank you.
Thank you. And